This unit will give you a better understanding of key courtroom terminology, how to prepare for the courtroom, how to act in a courtroom, opening and closing court, adjourning and reconvening court, swearing in a witness, and court proceedings. To fully understand the role bylaw officers play in court and courtroom proceedings, you will need to draw on much of the information we've touched on in the course so far. Your role in the courtroom involves ethics, public relations, public speaking, problem solving and CAPRA, note-taking, and the territorial acts. It can feel intimidating and overwhelming at first, but once you gain confidence in your abilities, the courtroom will be your chance to show off all the skills and knowledge you've gained along the way. If you think back to Unit 1, you'll remember that as a bylaw officer, you were given 3 main duties. You shall enforce those bylaws of the municipal corporation that you are appointed to enforce. You are an officer as defined in the Motor Vehicles Act and the Dog Act, and shall enforce those acts and the All-Terrain Vehicles Act. And you may represent the municipal corporation before a justice of the peace in the prosecution of a person charged with an offense under a bylaw. In this unit, we're going to focus on the 3rd duty. We will discuss the basics of the courtroom and give you the information you need to fulfill your courtroom responsibilities. But before we do, there are a few terms you'll need to be familiar with. The Justice of the Peace, or JP, is usually a member from the general public that has been trained in basic court procedures. They act as the judge in Justice of the Peace Court. Throughout this unit, whenever we use the term judge, this includes the JP. The defendant is the person who is charged with an offense. The offender is the person who has been found guilty of an offense. A jury is a group of 12 citizens selected according to law and sworn to inquire into and declare a verdict on matters of fact regarding a court case. The verdict is the decision of the judge or jury of whether or not the defendant is guilty. An acquittal is when the judge or jury decides that a person is not guilty of the crime with which they have been charged. A conviction is when the judge or jury decides the defendant is guilty of an offense. Conviction in absence is when the judge or jury makes a conviction without the defendant being present. The sentence is the punishment the judge gives to a person found guilty of a crime. An appeal is when a higher court reviews what happened at a trial in the lower court. The appeal may review the conviction, acquittal, or sentence given at a trial. Jurisdiction is the court's authority to hear a case. Evidence is the information given to prove that the accused is guilty or not guilty. Evidence can be something someone says, or it can be physical. For example, documents, photographs, or clothing are all forms of evidence. An exhibit is any document or other form of evidence provided to the court to support a claim. A preliminary hearing is when a judge looks at the case to decide if there is enough evidence to proceed with the trial. A non-jury trial is a trial held in the absence of a jury and decided by a judge. It is also known as a bench trial. Non-jury trials take less time than jury trials. An ex parte trial is a trial in which only one side appears before a judge. A dismissal is when a case is terminated. A subpoena is an order of the court for a person to appear in court and give evidence. A testimony is a formal written or spoken statement given by a witness under oath in a court of law. Try to get to know these terms on your own, as they will be very helpful in deepening your understanding of court and court procedures. In a trial, there are 2 opposing sides, just like there are 2 sides to every story. There is also a judge or a justice of the peace who is responsible for the final sentencing of the accused. The Crown represents a state or government, and the person who prosecutes the case for the Crown is the prosecutor. To prosecute means to lay a charge in a criminal matter against a person charged with a crime. The prosecutor acts on behalf of all members of the public, and his or her role is to prove beyond a reasonable doubt, that the offense was committed by the accused. A bylaw officer may act as a prosecutor for the Crown. Prosecuting cases is one of the key roles a bylaw officer plays in the courtroom. The defense is the person who represents the accused in court. The role of the defense is to do everything legally possible to achieve an acquittal for the accused, or if an acquittal is not possible, to lobby for the lightest sentence the law allows. In the case of a speeding ticket and other summary conviction offenses, the defendant would likely be their own defense. Judges are responsible for the conduct of every person in the courtroom. They ensure that both the Crown and Defense Counsel act in accordance with their obligations to the court and follow all the necessary procedures. They make decisions about the acceptability of evidence and the questioning of witnesses. In non-jury trials, the judge decides the guilt or innocence of the accused. In jury trials, the judge will sum up the evidence presented by both the Crown and the defense and instruct the jury regarding the law as it relates to the evidence they have heard. Witnesses have a very important role. Their testimony is a big part of the Crown's case against the accused. To make sure that all the facts in a case will be presented to the court, witnesses may receive a subpoena to testify in court. It is up to the prosecutor, which is often the bylaw officer in the case of Justice of the Peace Court, to help witnesses prepare to testify in court. Next, we're going to discuss the levels of court in the Northwest Territories. Justice of the Peace Court is the lowest court in the Northwest Territories. A JP can only hear summary conviction offenses. Trials held in Justice of the Peace Court will not have a jury. As a bylaw officer, most of your court dealings will be in Justice of the Peace Court. The Territorial Court hears the majority of criminal cases that come into the court system. The Territorial Court holds preliminary hearings and non-jury trials in communities throughout the Northwest Territories, visiting them regularly on regional circuits. The Territorial Court also has jurisdiction over all summary conviction offenses created by federal and territorial acts such as motor vehicle offenses and breaches of municipal bylaws. The Supreme Court hears civil and serious criminal cases, with or without a jury. It also handles appeals from both territorial and Justice of the Peace Courts. The appeal court may review the conviction, acquittal, or sentence given at a trial. Youth Justice Court hears all criminal code charges and Territorial Act offenses brought against young persons between the ages of 12 and 18. A youth justice trial can take place in the Supreme Court or in the Territorial Court, depending on the type of charge. The particular court that hears the case is designated as the Youth Justice Court, and the presiding judge is named as the Youth Justice Court Judge. Before you set foot inside the courtroom, there are many things you need to do to be prepared. If you are acting as the prosecutor, have your witnesses review their statements. You will also act as a witness in cases where you were the officer who issued the ticket. You will need to have all of the notes you've made concerning this case, and you should review your notes before coming to court. Also, bring any exhibits that will be entered into evidence with you, and they must be clearly marked for identification purposes. If you are not familiar with the courtroom, arrive early to get to know your surroundings. Make a mental note of where the witness box is, where the judge will sit, and where the prosecutor and defense will be seated. Look presentable and dress neatly. Speak clearly and always stand when speaking to a judge. You should also stand when the judge is speaking to you. Always be respectful and courteous towards the judge and everyone else in court. Do not interrupt anyone who is talking. Address both male and female JPs as Your Worship. Try to be quiet while court is in session. If you need to have a conversation, quietly leave the courtroom and do so. When entering and leaving the courtroom, it is customary to bow to the judge. even if he or she is not looking in your direction. Never be late for court. First of all, if you are late for court, the judge could dismiss the charge completely. Even if the proceedings go on as usual, being late puts everyone in a rushed state. If you're late, you won't get the chance to talk with your witnesses. Or if you are a witness, you won't be able to talk to the prosecutor. People also tend to forget details when they're rushed. As a bylaw enforcement officer, you may be involved in opening and closing court, as well as swearing in witnesses. To open a court, as the Justice of the Peace enters the courtroom, you say, "Order in the court, all rise." After the Justice of the Peace is seated, you say, "I declare this court open in the name of Her Majesty the Queen. Please be seated." To adjourn the court, you say, "Order in the court, all rise." When the Justice of the Peace leaves the courtroom, you say, "I declare this court adjourned for 30 minutes, or whatever the case may be." To adjourn means to put court proceedings on hold until a later stated time or place. To reconvene the court, as the Justice of the Peace enters, you say, "Order in the court, all rise." After the Justice of the Peace is seated, you say, "I declare this court reconvened. Please be seated." Reconvening is when you get back to court after a break. To swear in a witness, after the witness is in the witness stand, you say, "Take the Bible in your right hand." Then you say, "Do you swear the evidence you are about to give this court on the matter in question will be the truth, the whole truth, and nothing but the truth, so help you God?" The witness should answer, "I do." To close court, you say, "Order in the court, all rise." The justice will leave the room, and then you say, "I declare this court now closed. God save the Queen." The following is a brief overview of what happens in the courtroom. To become more familiar with how the court works in your community, you may need to work with the local RCMP. They will prosecute their own summary conviction offenses and can help you with your case. It may also be a good idea to sit in on a few court sessions to see how a bylaw officer performs his or her court duties. There are typically 4 different situations that you will be involved with in court. 1. The accused does not pay the fine before the court date and does not show up in court. In this case, you would ask for conviction in absence. This means there will be no trial, as the accused gave up their right to a trial by not showing up in court. For a conviction in absence, the judge will want all of the facts. They will also need to see the SOT and make sure everything is filled out correctly and that you followed the appropriate steps. If the judge accepts that all of the information is correct, the accused will be convicted of the fine that is specified on the SOT automatically. 2. The accused does not show up in court, but there is no fine specified on the SOT. In this case, an ex parte trial will be held. This is very similar to a conviction in absence, only there has to be a trial to determine the penalty. We will go over the steps of a trial in a moment. 3. The accused pleads guilty. If the accused pleads guilty, you, the bylaw officer, will read out the court brief in court. The court brief is a document explaining the charge. This is normally enough to convict the person of the charge. 4. The accused shows up in court and pleads not guilty. If the accused pleads not guilty, you have to be prepared for trial. Sometimes this means you will act as the prosecutor, and other times you will be testifying or speaking to sentence. Speaking to sentence means presenting all of the facts about the case to the court. If you are the officer who issued the ticket, you cannot act as the prosecutor because you were directly involved in the offense. Instead, you may be asked to speak to sentencing. If you were the issuing officer, another officer would have to act as the prosecutor. All Crown witnesses, which are witnesses testifying against the accused, will be called to give evidence in chronological order. Any exhibits or photographs should be entered into evidence by the witness who sees them or who took the pictures. It is very important that a certified copy of the bylaw is entered into evidence. When the prosecutor is finished stating their case, the accused can enter evidence if he or she wishes. Both the prosecutor and defense have the right to question the witness after the evidence has been entered. When both the prosecutor and the defense have presented their cases, a summary of the evidence is given. The judge will weigh all of the evidence, and if he or she feels the case has been proven beyond a reasonable doubt, he or she will convict the accused and impose a penalty. If the judge does not feel the case has been proven, he or she will dismiss the case. When testifying or speaking to sentence in Justice of the Peace Court, be aware that you may have to sit outside the courtroom until your turn comes to testify. When you are giving evidence, you will need to stand. Maintain good but not rigid posture. Remember your public speaking skills. When giving your evidence, speak to the judge. Try to paint a clear picture of exactly what happened at the scene of the offense for those who were not there. Listen carefully to any questions, and if you do not understand, do not be afraid to have the question repeated. Remember, once you answer a question, you cannot take the answer back. You must answer, to the best of your ability, all questions that are put to you. It is sometimes necessary and quite legal for you to consult your notes. Do not read them out loud. You are expected to testify from memory as much as possible. If you need to refresh your memory, ask permission from the judge to refer to your notes. Avoid discussing the facts of the case with anyone, and do not read or compare your notes or other evidence with your co-workers. It is essential that you maintain confidentiality until you present your evidence to the court. As we said earlier, it is very important that you become familiar with how the court works in your community. If you have questions about any of the information covered in this unit, don't hesitate to talk to your coworkers, your SAO, the RCMP, or your local MACA representative. And if you can, do sit in on some court sessions. That will be the easiest way to commit this information to memory.